Regency Factors PLC, and the Commissioners for Her Majesty's Revenue and Customs.
Yes, Mr. Ripley.
Good morning. I appear on behalf of the appellant Regency Factors.
Yeah.
My learned friend, Ms. Lambert, appears on behalf of the Commissioners. Just, if I may, start with some housekeeping.
Yes, perhaps before you even do that, though, maybe this is one of the points you were going to raise. Our view, unless the Council want to try to dissuade us, is that it makes sense to hear the appeal first, to hear both parties on the appeal, and then we'll see where we are on the respondent's notice.
Understood.
If that creates real difficulties, say so, but it doesn't seem to us that it should.
Not for me. So, my Lord, in terms of housekeeping, hopefully you have 3 bundles.
Yes, so far so good.
Just a brief introduction to the appeal. The case concerns the availability of bad debt relief for VAT purposes in the context of Regency's with recourse debt factoring business. So in outline, bad debt relief, or sometimes I may say BDR, is the UK's implementation of Article 90 of the Principal Vat Directive, which entitles taxpayers to a refund wherever they have accounted to the revenue for VAT on their sales, then subsequently not received payment from the customer. Now, there are 3 issues before you, and I think my Lord's identified this already. First is whether Regency's claim falls to be rejected as a result of its record keeping, as held by the tribunals below. That's my appeal, which I'll deal with first. And then there are 2 issues raised by the respondent's notice. I'll just outline them. The first is whether Regency had received payment for its services up front so that there was no non-payment or bad debt. This is the first of the points raised in the respondent's notice. And that's at paragraphs 9 to 10. And the second point raised in the respondent's notice is whether Regency falls to be denied for the further reason that in reality there's little risk that Regency is left out of pocket. And that's the second point raised at paragraph 11 of the respondent's notice. So then, turning then to the first issue, the formalities required for a bad debt relief claim. If I may, the way I'll structure this is first look at the legislation, then the case law, and then finally say how it applies here.
Certainly.
So this ground proceeds on the basis that Regency can satisfy the substantive requirements for Article 90 relief, and in particular that it did not receive the consideration for its supply. Now, the first relevant bit of legislation is the Principal VAT Directive. It's in tab 1 of the authorities bundle, page 3. I'm looking at Article 73.
Now, you say that you proceed on the assumption that the Regency can satisfy the substantive requirements, but didn't the FTT find that because of the state of the records, it was impossible to say whether Regency had or had not satisfied the substantive requirements?
So that's a point that my learned friend puts against me. I say that the FTT decision can't be read in that way, and the reason is that first of all, it was conceded that there was a debt. I can show the reference to the witness statement if need be. The other substantive requirements, and perhaps once I've shown you section 36, we can see what they are. But the only real question, as I understand it, is about whether or not we kept all the records in a single account. And there is that slightly bizarre bit in the FTT decision, which I will need to take you to in some detail at 119, where after having assumed that Regency has all the records listed in Reg 1682, which we will look at, it then says that it's impossible to work out whether or not that bad debt relief it qualifies for bad debt relief. Now, I will go to the FTT decision unless you want me to do that first.
Up to you.
If I may, I'll start with the legislation and build towards the FTT decision. So the first is Article 73, which is on page 3 of the bundle. This just sets out the rule for what is the consideration for VAT purposes. And I simply say at this stage that it has a special EU definition. It's obviously been the subject of extensive case law, so it has an autonomous meaning for the purposes of EU law. Now, the mirror provision, because I should say Article 73 includes everything to be obtained by the supplier, the mirror provision is Article 90, which provides for reductions in the taxable amount, including, Article 90 on page 7, including in several circumstances. The relevant one here is total or partial non-payment. And it says the taxable amount shall be reduced accordingly under conditions which should be determined by member states. And then just to note, paragraph 2 says, in the case of total or partial non-payment, member states may derogate from paragraph 1. Now, again, we'll see in due course that although on its face this appears to give member states a wide discretion, through its case law, the Court of Justice has made clear that both the conditions and the scope of the derogation are tightly restricted. So much for the directive. The UK legislation starts at section 36 of the VAT Act, which is
I think we need to look at Article 273.
We can. I'm sorry, I should look at 273. So that's at the bottom of 8, and of course that allows member states, it's another provision allowing member states to impose other obligations, and of course it's a provision which is mentioned in the case law. So, section 36 of the VAT Act is at tab 5, page 12 of the Neutralities bundle. Subsection 1 sets out the 3 basic gateway conditions. If I just summarise, VAT has been accounted for on a supply of goods or services. B, the consideration must have been written off in the accounts. And C, a period of 6 months must have elapsed. Now, subsection 2 gives relief for the outstanding amount. In essence, it's the lower of the amounts received and the amounts written off in the, or rather the lower of the amounts outstanding and the amounts written off in the claimant's accounts. As I say, it's common ground that consideration in this context means this autonomous EU law concept of consideration for VAT purposes. Just to note, subsections 5 and 6 enable regulations to be made for various purposes, including the records to be kept in support of the claimant, B and C. D allows regulations to require the repayment of a refund under this section where any requirement for regulations is not complied with. And E allows regulations to be made to require the repayment, in effect, where the supplier later gets the cash in after having claimed bad debt relief. And we'll see that the regulations do that. So the UK rules are slightly different from some other member states. In effect, once you reach that 6-month end period, so it's been outstanding for that long, you can claim bad debt relief if it's written off in your accounts. But then if you later receive it, it's recouped by the Exchequer.
Is it important that it's different from some other member states? In which case, you just tell us in what respect it's different.
Well, in some other member states, and we'll see in some of the Court of Justice cases, it talks about conditions around whether or not the debt is permanently irrecoverable. But the UK doesn't take that approach of requiring it to be permanently irrecoverable.
Yeah. Thank you.
Perhaps now if we get to the nub of the regulations, and in particular Regulation 168, it's at tab 7, and it should be on page 22. Can I just invite you to remind yourselves of that provision, please?
On a point of absolutely no importance, except it made me wonder whether it had been correctly reproduced in 168(2)(e). It says regulations plural, but it should be regulations singular, shouldn't it? That's just a typo of some sort, or a reflection of the once there were more regulations.
Yes. If I may, I will check whether.
Well, I have checked. Honestly, I said it was of absolutely no importance. It just irritated me, and I thought I'd make sure I hadn't missed something silly.
Is it a fault in this copy of the authority?
No, I think it's if you look online, it's the same. So I suspect there were once more than one regulation, and they just didn't correct them. Spend no more time on it, Mr. Ripley.
I'm grateful.
Got it off my chest.
So paragraph 1 is the requirement to keep a record. Paragraph 2 then lists the details that must be kept, subject to a discretion of the revenue. And then paragraph 3 says that records created in pursuance of the regulation must be kept in a single account. And so I'm contrasting keeping a record with records created in pursuance of the regulation. And I think one can make that good also by looking at the specific items in paragraph 2, in particular the last one, which is the one we've just been looking at, a copy of the notice required to be given in accordance with the regulation. That's Regulation 166A. That is not created in pursuance of Regulation 168. It's created in pursuance of a different regulation. And given that it's common ground that the account required by paragraph 3 means effectively a ledger spreadsheet, it would be rather odd if the draftsman here were requiring a copy of the notice to be embedded somehow in the ledger or spreadsheet. And yet that is the approach of the Upper Tribunal, who in effect found that paragraph 3 means all the records listed by paragraph 2 must be kept in a single account, and that was also the approach of the FTT. Now we say, insofar as taxpayers have to create records in order to comply with Regulation 168(2), those are the records which must be kept in the single account called the Refunds for Bad Debts account. That strikes a fair balance between the convenience for the revenue and the burdens on taxpayers by accepting that some records will not have been created in order to comply with the regulation, and taxpayers do not need to go to the trouble of consolidating those records into a single account.
Just one moment. Yeah, thank you.
There's another regulation which I'd like to look at while we're here, and that's Regulation 171, which is on page 26. And in particular, it's well, just to note in passing that I talked about the ability to recoup if you do receive payment later, and that's provided for by paragraph 1. But the paragraph I really wanted to look at is paragraph 3. And can I just invite you to read that, please?
Yes.
Now, what is supposed to happen then is that the revenue is supposed to consider whether to allow a claim despite a failure to comply with Regulation 168, which is one of the regulations specifically mentioned. And if the revenue decide not to allow the claim, then it must direct the taxpayer to make an adjustment in a subsequent return. I'll explain it in a moment. That's not what happened here, because the assessments that were raised corrected the original returns for a different reason, and then at the FTT, the record keeping was used as an additional reason to support that rejection.
Is that just part of the history, or are you making a particular point about that?
I am making a point when we come to the European law. It's not a case of the UK saying, here's a way in which you can satisfy us that you have an entitlement to an Article 90 relief. What's actually being done here is that the condition is being used to justify a decision that was made for a different reason. So,
But why?
So
Why is that inadmissible as such?
Sorry, say that again.
Is that inadmissible to do that?
Well,
Or impermissible?
I say that the proper way to deal with a failure to comply with Regulation 168 is to follow the procedure set out here in Reg 1713.
But that was never a ground of challenge, was it?
It was not a ground of challenge in the first tier.
Or in the second tier?
And the Upper Tribunal said that it was not, that's right.
So
But
that's
So
why I asked.
you didn't get permission to appeal on that ground, I think is what they said, wasn't it?
They did say that it was not within their jurisdiction. But I mean, in my grounds to this court, I squarely say that the revenue are not entitled to reject the claims
Well,
for bad debt
you
relief.
may be, but if it's not an issue in the appeal, it doesn't help you to establish that.
Well,
That's why I wanted to be clear. If it feeds into one of your other arguments, so be it. But I don't see at the moment how, even if you're right about it, it's a ground on which you can succeed in this appeal, because it wasn't taken in the FTT, it wasn't allowed to be taken in the UT, and you didn't get permission in relation to it.
in this court,
Yeah.
my grounds are deliberately framed quite broadly, and it was in my permission to appeal
Well,
scarce.
that doesn't get you. That's not a get out of jail free card. You still got to satisfy us that the UT made an error of law. And if they refuse to entertain the argument, it's difficult to see how you could do that.
Understood. In that case, the only other relevance of the point is in relation to whether or not somehow the discretion of the revenue provided for in the regulations
mitigates Regulation 168, and that's
Indeed.
the point the UT did make.
Yes. And I say that there simply wasn't the exercise of discretion here. They didn't go through the process which is provided for.
Can I ask you another question?
Yes.
Is there anything in the regulations that requires records to be kept electronically on a computer somewhere?
Requires them to be kept electronically, not as far as I'm aware.
No. So going back to your point about Regulation 168, if you have kept your records on paper, and they are a collection of unsorted bits of paper in boxes scattered around the office, you say that's good enough.
Yes. So long as, if pressed, you can prove your substantive entitlement. And perhaps this is a good moment to turn to the case law. So this looks at the scope of the discretion open to member states. Most of the cases are very recent and actually post-date the UK legislation which we've looked at. In the four most recent cases to reach the Court of Justice, Hungary, Slovenia and Czech Republic were all found to have set conditions which impermissibly restricted Article 90. But if I may, I intend to just show you two decisions. The first is Trotave, tab 19, and it starts on page 194. Just by way of outline, the case concerned a company in Portugal which provided certain wastewater services. It sought an Article 90 reduction in respect of payments due from 8 customers. The tax authorities refused because Trotave had not notified those 8 customers of the adjustment. And the point being that those customers would have then made an adjustment of their own. So the question for the Court of Justice was whether that requirement was permissible. And if I could just invite you to read paragraph 29, which is on page 197.
Yes.
And then at paragraphs 30 and 31, they note the existence of member states to the power to derogate and the right to impose obligations under Article 273. And then at 33 to 34, the margin of discretion is heavily circumscribed. Can I just invite you to read paragraphs 33 and 34?
Yes.
So the Court of Justice then makes clear that the Portuguese requirement does pursue a legitimate objective, that's in paragraphs 35 to 36, because it informs the debtor that they also need to make an adjustment. And that's plainly concerned with ensuring the correct collection of VAT by Portugal, albeit in relation to the customer rather than the claimant Trotave. The next case, if I may, is SCT at tab 14. Now, SCT made an Article 90 adjustment in relation to supplies to 2 customers which had been through insolvency proceedings. And Slovenian tax law made that adjustment conditional on claims having been lodged in the insolvency proceedings, which SCT had not done. Now, paragraph 21 on page 137, the Court of Justice repeats the passage that we've just seen in Trotave about Article 90 embodying a fundamental principle. And then over the page at paragraphs 33 to 35, the Court of Justice then repeats that there's a margin of discretion for member states, and paragraphs 36 to 37 effectively state the same limitations on that discretion. Now, at 41, the court explains that that failure to lodge a claim means that the taxpayer may lose its chance to collect, in effect. And so, again, this goes to ensuring the correct collection of tax. 42 notes that lodging a claim is not unduly onerous. 43, can I invite you to read that?
Yes.
So the key point is that even though the requirement to lodge a claim in the insolvency proceedings contributed to the correct collection of VAT, even though it was not onerous, Slovenia were precluded from applying the legislation if the taxpayer could show that lodging a claim would not have yielded additional monies. And then finally, just to note, while we're here, and to avoid turning up one of the other cases, at paragraph 50, the court records the earlier decision in Almos that Article 90 was directed. So if I may just draw the threads together from the two cases we've looked at. I draw 4 points from it. First, Article 90 is a fundamental provision which the Court of Justice is cautious about any restrictions on taxpayers' rights to an adjustment. Second, any such restriction must pursue a permissible objective. And we saw in each of the cases...
Must pursue a what objective?
Permissible objective.
Permissible.
And each of the cases where it was held to pursue a permissible objective, that was because it either affected how much tax the customer would pay or how much consideration the taxpayer would receive. That, I understand, is what the court means by ensuring the correct collection of tax. But even where the...
So how much tax the customer would pay, I get that. What was the alternative?
The one in is it SCT is not about how much tax the customer pays, but it was about lodging a claim in the insolvency proceedings.
Yes,
if it had done so and it could have got additional monies in,
yeah,
then the condition would have avoided the need for an Article 90 relief. So it affects how much money the Slovenian Exchequer would have got.
Yeah.
Now, even where the objective is permissible, this is my third point, it must not go further than necessary. And in SCT...
Is that just another way of saying proportionate, or is that not quite the same thing?
No, in SCT that meant accommodating a taxpayer who could show that taking a simple administrative step would not have made a difference. And then fourthly, just to note, none of the cases, as far as we're aware, had any support for a case that an administrative convenience of the tax authorities say having fewer documents to look at, that alone is sufficient to justify a particular formality.
That's the sort of proving that I see why you say that on the basis of the two cases you've shown us. You're saying, nor are there any other cases of which you are aware.
I am saying that, and I could show you some other examples of Article 90 cases, but they're not similar to this particular provision or this particular condition.
I don't think we've got the recitals to the directive, but I think recital 59 tells us that simplification of the process is one of the reasons why a member state can invoke Article 273.
Quite, and indeed, and this, I should have said, this goes back to perhaps why I skipped over it when I shouldn't have, when we went through the legislation. In this particular context, in the context of Article 90, what the court is saying is, this is such an important principle, it goes to the heart of that, the principle of neutrality, reducing the taxable amount. It's so important that the condition, that the obligations your member states are allowed to impose on taxpayers here are heavily circumscribed.
Yeah.
And so my lord is quite right. And it may well be that my learned friend is right when she says in her skeleton that Article 273 allows a wide discretion in other circumstances, but not here.
Right. Can I, are you finished with the European cases?
Yes, my lord.
Can I ask you about the Advocate General's opinion in ESP, which is at tab 13?
Yes.
If you look at paragraph 38 on page 124 of our bundle, she says it's possible to infer from the case law certain differentiation as to whether and how restrictions the adjustment of taxable amount within Article 90 can be justified. The court distinguishes between substantive aspects for derogation and formal aspects. Both derogations and conditions must be proportionate. So she sees a distinction between a substantive block on the right to an adjustment and a formal aspect.
Yes.
And it might be said that Regulation 168 is a formal aspect.
Indeed. And I think I would accept that. And indeed, member states must be entitled to provide for formalities which allow taxpayers to prove their entitlement to Article 90 relief.
Yeah. Did I understand you to accept that Regulation 168 was a formality?
Yes, I do accept that. I do still, of course, still say that if the condition is being used to restrict relief, it must still meet those conditions of pursuing a permissible objective and going no further than strictly necessary. And I've emphasised the passage in SCT where Slovenia was forced to see if it would have made any difference if they'd complied with the particular requirement. So if I may then turn to how I say this applies here. Again, perhaps we don't need to turn it up, but for your note at Core Bundle, tab 10, page 100, that's the appealable decision from the revenue. And the points that I was just going to make in relation to it, which we've covered. At this stage, the sole reason given for refusing bad debt relief is that consideration had been received, i.e. that's the point on which Regency successfully challenged in the Upper Tribunal. I said 3 points, it's actually only 2. Secondly, consistent with that conclusion, the commissioners do not invite Regency to correct a future return, and we've covered that. The FTT decision then, that's in the core bundle. Tab 10.
Sorry, I'm slightly behind. The second of your 2 points is that the taxpayer was not invited to
correct a future return, and we had the exchange in that I'm not entitled to criticise the revenue on that basis.
yes, FTT.
FTT decision. Can I invite you to turn up tab 10, page 74 is where it starts. It may be relevant to the discussion we're going to have about 119 in a moment, but the FTT at paragraph 2 accepts the truthfulness of the witness evidence from Regency Factors, and indeed accepts the evidence of the revenue at paragraph 3.
So he's found Mr. Farrell's evidence rather difficult to understand, I think.
Had some difficult. I think in this particular paragraph, he says that it's truthful and credible, and that there were opinions expressed relating to matters which were in the FTT's functions. And of course, I've no criticism about the FTT deciding what it feels it has to decide. But there is also later, my lord, you're right, some difficulty in understanding the way that it worked. And it is very detailed, the witness statements. Now, at paragraph 92, just to note submission, I should say I didn't appear in the FTT, but it's clearly recorded.
Sorry, just before we get there.
Yes.
We're looking at Mr. Farrell's evidence, and at paragraph 15,
Yes.
the FTT quotes from that evidence, and it says part of what the FTT accepted, and he says the FCA, which is one of the various accounts that Regency keeps, is a running account balance. There is an admixture of funds. It is impossible, this is Mr. Farrell's words, to apportion credits to particular invoices submitted by a client and receipts from their customer. And the way that he was making his claim was by applying what he called the concept of pari passu. So, on Mr. Farrell's evidence, you cannot say, in relation to any particular supply, what the position is.
My lord, this is one of my criticisms of when we get to paragraph 119. I think that there's a danger of misreading this quote from his witness statement, because he is here dealing only with the FCA, so the factor's current account. One can see from paragraphs 9 and 10 that there were other ledgers. And so 9 refers to the overall sales ledger, OSL. 10 deals with the customer sales ledger, SCL. And then at 11, the tribunal says, I find the following facts. Can I just invite you to read 11.8?
11.8.
Yeah, sorry, sub-paragraph 8 of 11. So may have picked up from the Upper Tribunal decision that this is an exchange that was had below, which was whether or not, when there's a collection in from the customer, whether or not that can be attributed to any particular invoice. And the tribunal says that on instructions I had told them that it was possible, but the tribunal also noted that 11.8 is a finding to the effect that one can do that. And so
Specifically by reference to the CSL.
specifically by reference to the CSL. So it's not the FCA. And perhaps I'll again come back to how that feeds into my criticism of paragraph 119 in a moment. If I may, I'd like to show you paragraph 92 next, just very briefly. It's on page 95 of the bundle. So this is recording what Regency put forward, and it says, as to the record keeping, they refer to each subparagraph of Regulation 1682 of the VAT Regulations and point to where the relevant record is kept. A slight disadvantage here because we don't have all the exhibits from the witness statements, but I simply say that was the case that was run below. And note also in 93 there was something called the bad debt write-off account, but it is common ground that that does not contain everything that's required by Regulation 1682.
Hang on 1 second. Yeah. So, sorry, yes, although where it says the record was therefore by Regulation 168, that is the submission, yeah. And when it's common ground, that's not the case.
It's not a finding. Then the sort of key paragraph, which perhaps I hang my hat on, is 117 on page 98. Can I just invite you to read that?
But the bad debts write-off account referred to, I think you accept, does not contain all the records required by Regulation 1682.
Correct. Otherwise we would have a single ledger, and we don't.
Yes, so what points do you make about that paragraph?
So the key point is that the tribunal proceeds on an assumption that Regency has all the records. Now I accept, as the Upper Tribunal found, this is not a finding of fact that it did have all the records, but that is the assumption on which the decision is based. And no requirement in Regulation 1682 is mentioned. The only requirement which is mentioned is the failure to keep a single ledger in 1683. Now,
Hang on 1 second. Yeah, thank you.
now, I should say for completeness that this is of course the second time we've had the fight about whether or not 1683 really requires a single ledger. And it has not been said below, and and I do not understand it to be said here, that there's some other specific requirement of 1682 which is missing. Because if that were said, then we could try and find the documents to show that it was exhibited to the witness statement. In any event, against that background,
So you're saying the point the case is only about 1683.
That is my case. And I should also say though that I'm not seeking to shut the revenue out from saying they can't, that we don't have to prove it. If I don't have a finding that we had all of the right records, it can only go back to the FTT for us to prove our case. But I do say that this appeal is only about Regulation 1683, whether or not it requires a single ledger, and if so, whether that's permissible as a matter of EU law.
Well, that's quite a difficult question. In the Slovenian case, as I understand it, the requirement to lodge a claim in insolvency proceedings was a legitimate requirement. What the court said was that Slovenia can't rely on it if the taxpayer showed, taxable person showed, that lodging the claim would have made no difference.
Yeah.
Now let's transpose that to Regulation 1683. Your argument, I think, is, maybe at any rate, Regulation 1683 pursues a legitimate purpose. It is in itself compliant with EU law, but it can't be relied on against a taxable person who can prove by other means than a single account, A, that he has all the records required by Regulation 1682, and that he satisfies the other substantive conditions for bad debt relief. Or are you saying that Regulation 1683 is invalid under EU law? Are you taking that position, or are you saying, well, it might be, depending on the facts?
So I suppose taking it in stages, I have three main lines of defence. The first is, on an ordinary construction of 1683, it only refers to records created.
Yes, I understand that.
If I'm right about that, I don't need EU law. If I'm wrong about that, then I do say that it does not pursue a permissible objective if interpreted in that way, so as to require a duplication of an audit trail that already exists.
Hang on 1 second. Because the most that can be said about that is that it will be more convenient.
Indeed.
Yep.
And if I'm wrong about that, and it is the sort of formal requirement that ensures the correct collection of tax and is therefore permissible, then we come back to my Lord's point that I say it goes beyond what's strictly necessary to enforce that against a taxpayer who can otherwise prove that they meet the conditions.
But, sorry, I'm jumping on my Lord's bandwagon, perhaps differently from how he would. Are you in a position to make that proof, given the absence of findings?
To
prove that you could in fact show that you, by reference to proper record kept under 1682, albeit not in a single account, that the bad debt did in fact exist.
And
Which
the
I think is the point that
yes.
my lord was drawing out of you.
And I accept not in this court. So what I can't do is get you to make a finding of fact that Regulation 1682 was complied with in full. But I do say that my clients ought to have the opportunity to make that case. And here what the First Tier Tribunal has done is to say, well, let's just assume you've got all the records required by the UK statute. You still fail because of Regulation 1683 alone. And that's the nub of my complaint. Now, having looked at 117...
What was that way of putting it? That's why you showed us how it was put. That way, you say that way of put that it was put that way to the FTT, but the FTT took this shortcut, which deprived you of the ammunition on which you could rely on it here.
Yes.
And it was put to the Upper Tribunal as well?
I'm sorry,
Was it put to the Upper Tribunal as well?
It was put in the same way that I have. I don't think I invited the tribunal to make a finding. I can't now remember, but I did say that at the least we need to be able to make our case that we have all the records. Now, what I haven't done is read 118 and 119, which are the paragraphs which my lord started with. My shortcut would be to say, in light of 117, it's difficult to know what they mean when they say at 119. It's impossible to say whether the necessary conditions for BDR are met. Nor is it clear what is meant by any discrepancies. In particular, the only witness statement given by the revenue is before some of the exhibits provided afterwards as part of the litigation. So simply referring to what the revenue has pointed out at an earlier point doesn't tell you whether or not the tribunal had enough to decide whether or not these requirements were met.
Seems to be coming quite close to quarrelling with the FTT's findings of fact.
I have to say that either 119 is not a finding of fact, or it's inconsistent with 117, which clearly says they have no reason to doubt they keep the records as listed. I was next going to turn to the Upper Tribunal decision, if I may. It's at tab 6 of the core bundle, starts at page 36, and this particular issue starts at page 56, or the discussion of it.
Can we just look at your grounds of appeal?
Yes.
Because I think one of the points the Upper Tribunal made was that one of the arguments you deployed wasn't within the grant of permission to appeal. So we better just have a look at that.
I don't think we have the grounds of appeal to the Upper Tribunal.
To the Upper Tribunal, yes.
Do you not?
You don't have those?
I thought you... they're standardly in there. I thought they were in... Are they not at 65? Oh, no, I see. No, sorry.
Well, we have my application for permission to appeal to the Upper Tribunal at tab 8. That's quite right. So
well, I'm not sure I am right. But let's have a look at that and just be sure. I think that's your application for permission to appeal here.
Yeah.
So, those probably help me. It is here.
Are we at cross purposes?
Well, I think you summarised the grounds of appeal before the Upper Tribunal.
Oh, I see.
In paragraph 3.
Yes.
And I don't see in those grounds of appeal the argument that the regulation goes beyond what is necessary to enforce against a taxable person who can prove he has the necessary records, and that Regency ought to be allowed to have that opportunity?
Agreed. It doesn't set it out in those terms. All it says here is the FTT misinterpreted the requirements of the regulations, and in my submission, the Court of Justice case law is relevant to the interpretation of those of Regulation 1683.
Sorry, I was just making a note. On which of those grounds do you pin that point? Do you say it's covered?
It's ground 4. I'm sorry, it's ground 4.
Yes, I see.
That's the only relevant ground.
And you say that the HMRC's discretion not to require compliance with Regulation 168 is not sufficient to cater for the case in your third argument, that is to say the taxable person can show by other means that he has the necessary records and that he is entitled to bad debt relief.
So it could be, if the discretion is exercised.
Yeah, but you haven't complained about the exercise or non-exercise of discretion. We are concerned, as I understand it, only with the question whether, well, it's not even whether Regulation 1683 is compliant with EU law. It's whether the VAT regulations taken as a whole are compliant with EU law.
I understand.
And if Regulation 1683 says you must keep a single account, and Regulation 163A said, but if you don't keep a single account and you can prove that you've got all the right records, you can still claim bad debt relief, you couldn't possibly quarrel with that, could you?
Sorry, no, I understand, my lord. So no, if it in effect removed the requirement.
Yeah. And then the question is whether the HMRC's discretion, which might be challenged in another case, is sufficient to undo what is apparently an absolute requirement of Regulation 1683.
If I can just try and put it from my client's perspective.
Yeah.
What's happened here is the procedure for the exercise of discretion, where you ask an adjustment to be made to the latest tax return, that hasn't been followed. So the only decision which they have is the assessment reversing the original claims. And that's the decision which they appealed, and the FTT knocked it out on the basis that there is a requirement under 1683. Now, if that discretion is to be relied upon, in my submission, it can only be relied upon if they have followed that process of saying, well, look at your records, you can't rely on our discretion because we want it in a single ledger in your particular case, and therefore you must correct a future return. Then that would be a different decision and an exercise of discretion which Regency could challenge. But here, the sole basis on which we're being knocked down is that we didn't have it in a single ledger, and there was no exercise of discretion.
But isn't that for you to raise as a ground of appeal? You say, well, even if you're right about Section 168 and Regulation 1683, nevertheless, we appeal because you didn't exercise your discretion properly. But that wasn't ever an issue.
But, forgive me, is that not then part of the requirements of the regulations? If one has to look at the regulations as a whole, and Reg 1713 was not followed.
Can I just ask this, which is another aspect of this. Suppose the regulation itself is unobjectionable, let's say 1683, but the result of Slovenia is you must have the chance to prove that your breach of the regulation hasn't made any difference. Quite before you even get to the stage of appealing, don't you have to say to the revenue, I know I haven't complied with 1683, but it hasn't made any difference because I can demonstrate it from the records that I have under 1682. I'll call on you to exercise your discretion having considered the proof which I tender, not to disallow the relief. And then if they say, no, we're just going to stick to the letter of 1683, or no, 1682 doesn't show what you say it shows. Your records you've kept under 1682 don't show what you say they show. At that point, there is a decision which may be contrary to Slovenia, but not until that point. It's clear from the Slovenia case that the burden is on you to advance the case. That's really the point I'm making rather long-windedly.
Yes. Well, in this case, that there would have been no point in asking the revenue to exercise a discretion to allow bad debt relief, notwithstanding the absence of a single ledger, because they were disallowing it for an entirely separate reason.
Yes, I see. So this is how your point perhaps comes in.
So 1683 is raised in the First Tier Tribunal, and I don't criticise the revenue for raising it, but it's being used to support a decision that was made for a different reason. And the response of Regency was to say, first of all, we don't even think that Reg 1683 requires a single ledger, so you don't have a discretion to exercise because we haven't done anything wrong. But in any event, we can show that we've got all the records under Regulation 168.
So you advanced your point at the first stage at which 1683 was relied on by the revenue.
Yes.
Yes, I see. So your point about the wrong procedure having been followed is relevant, as it were, as a shield to you for not having taken the point before.
I think so, my lord, yes.
Thank you. I'm sorry that I'm not. I rather took over my lord's line of questioning to raise a different point, but I don't know whether.
I wanted to just look at the Upper Tribunal decision, if I may. Paragraph 89.
89?
Yes, this is the nub of the reasoning. Now, the Upper Tribunal obviously rejects what I say is the ordinary reading of Regulation 1683, and I say they were wrong to do so for the reasons that I gave, and I shan't repeat. Then at 90, the Upper Tribunal also rejects Regency's case that EU law prevents Regency from being denied bad debt relief on the basis of such an administrative condition. And the Upper Tribunal says, in the second sentence, whilst there are limitations on the conditions and requirements that member states can impose, such restrictions are engaged where the conditions for relief go beyond the margin of discretion and make the claiming of relief impossible or excessively difficult. So I agree with the first part of that. that it's engaged where the conditions for relief go beyond the margin of discretion. But as we've seen, that's a much narrower margin of discretion than simply whether or not claiming of relief is impossible or excessively difficult.
Where does the language of claiming impossible or excessively difficult, which is very common CJEU language, we haven't seen that, I think, in either Tratave or Slovenia, or did we?
No, forgive me, I haven't taken you to Polska Foods, which is Kraft Polska Foods, which is the decision which the Upper Tribunal draws from.
Yes, well, perhaps we didn't go to it, perhaps, but can you just show us where in 84 and 85? Well, it's presumably 85, is that the dispositive?
That is
Yes.
the dispositive, yeah.
And there we see, yes, where it's impossible. I see, so it's more or less a straight lift. Can I just, we may or may not need to go, you may want to take us to Polster, or might, Ms. Lambert may wish to, but let's just quickly look at the passage quoted here. Well, 28 and 29. 28 looked pretty like the passages you've taken us to. This is a much older case, isn't it? So it has different references. And then 29 says, consequently, and the test then is impossible or excessively difficult.
Indeed. And so one way of reading Polska Foods, as the Upper Tribunal does, is to say that the touchstone here is what I'm going to call the principle of effectiveness. But the more recent case law makes clear, at the very least, that is not the only touchstone. I should say Polska Foods was not a case cited to the Upper Tribunal. I'm not criticising the Upper Tribunal for referring to it, but it predates Tratave, and it predates...
Not a case cited to it by either of the parties?
Neither side, no.
So you're really saying Tratave has qualified or glossed or refined the principles appearing from Polska Foods?
I certainly say it's refined. I mean, whether or not it's changed Polska Foods depends on whether one reads the word consequently as in 29, suggesting that's the only condition you need to meet. But I do say it's clear from Tratave, SCT, and there are some more recent cases in the bundle which repeat Tratave and SCT, that the margin of discretion is much narrower than simply asking does it meet the principle of effectiveness.
But there's no decision of the court or opinion of the Advocate General that explicitly considers the relationship between that more recent jurisprudence and Polska Foods. I know that the court very rarely does that sort of thing, but the Advocate General sometimes does.
Yeah, no, I'm not aware of it. No. The only Advocate General opinion which has any discussion of this is, I think, in the paragraph which my Lord took.
But certainly on reading, I'm afraid, only passages set out by the Upper Tribunal. You really have to say that the law has changed or been nuanced in some way by the later cases to which you refer.
Quite. So allow me to accept I am not relying on putting something into a single ledger is being too onerous, such that it makes a claim excessively difficult.
Yeah.
That's not my case. Our real complaint is...
Polska Foods is a formalities case. Going back to the distinction that the Advocate General drew in the ESP case. What they're saying in the paragraphs that are quoted at 84 of the Upper Tribunal, paragraph 23, they say, provisions give the member states a margin of discretion inter alia as to the formalities to be complied with. Clearly, having an invoice or a copy invoice, or correcting invoice, is a formality.
For my part, my Lord, I don't mind if it's put into the formalities category, But I do say it's a very different kind of formality than the one here. And the reason is because it's a case parallel to Tritave, actually, where notice was required to be given. So again, just by way of background, Polska Foods is not a non-payment case. It's actually a reduction in consideration case. So say you've agreed that the invoice you issued should have been 100 less. What was supposed to happen under, I think, the Polish rules, was you were supposed to notify your customer that you were reducing the consideration. Why does that matter? Because your customer will have made an input tax claim. And so again, it goes to ensuring the correct collection of tax, because the customer knows that they then have to make an adjustment increasing their VAT liability to the tax authorities. But there's a very different kind of formality to the one here, which doesn't appear to affect the amount of tax in any way. It's just about whether or not the revenue have to look at, if I put it crudely, one piece of paper or several. I'm afraid this, I hope I don't repeat too much our exchange earlier, but if I just complete my submissions on this section. The question is whether the conditioning here pursues a recognised objective, and if so, whether it's strictly necessary, even in circumstances where the taxpayer says they can provide all the same data, just not in a single ledger. In our submission here, Reg 1683 is being deployed purely as an administrative requirement. It does not ensure the correct collection of tax, and it undermines neutrality by making Regency bear the burden of the VAT on consideration it has never received.
Sorry, say that last bit again. Places the burden on Regency.
Yeah, making Regency bear the burden of that on consideration it has never received.
May never have received, or has never received, or may never have received. You say has never received because you accept you've got to show that it actually did receive.
Indeed.
Or didn't receive it. Yeah.
Didn't receive. Although again, we can look at revenues. Perhaps it would be worth just turning this up because it'll save me coming to it later. What the revenue said in their witness evidence before the first hear, it's the second witness statement of Officer Munir in the supplementary bundle at tab, it must be tab 4, page 39. So it's the under the words Regency's entitlement to bad debt relief starts by saying no different here to other cases. Then E says, however, in the event it is decided that the restriction to the drawdown, that is in effect what the revenue says, the deduction of fees from the initial advance. That's the respondent's notice point. Is consideration, which I believe to be the case, then I can see that consider Regency did in the event receive payment. So that's the respondent's notice point. F, can I just invite you to read that?
That's where Regulation 168 comes in.
Yes. So I say in terms of the substantive question of whether or not we had a debt, that was conceded below, subject only to the respondent's notice point about whether there had been payment made in advance.
case is being advanced squarely on the basis that they don't comply with the record keeping inquiries, that's the end of the matter, even in circumstances where a consideration hasn't been received.
Yeah, even in circumstances where they are, the revenue, the commissioners are satisfied there is a debt. That does complete my submissions on the first issue and my appeal. Would you like me to continue to issue 2, the respondent's notice, or would you like?
Well, no, I think our indication at the start was that we wanted to hear from Ms. Lambert. Thank you, it was very clear and succinct. You can remove your mask, Ms. Lambert.
I've got so used to it, my lord. I thought it was on. Thank you.
Plan B has gone today.
Nevertheless,
No, well, HMRC regime has not yet been changed, but even on that restrictive regime, the speaker is allowed to remove their mask.
the issue of in this round of appeal raised by the appellant focuses on Regulation 163. But as my lord correctly noted, one needs to look at Regulation 163 in the context of the entire VAT Regulations. And also specifically whether if the appellant is able to prove in the absence of the records required by 163, there is any provision for HMRC to recognise a valid bad debt relief claim. Because this point has been raised a number of times by my learned friend, I thought I'd address this first, if I may.
Yes.
There is, or has been, no concession on the part of HMRC that Regency, the appellant, does in fact have the evidence to prove a valid bad debt relief claim. That wasn't the case in its compliance visits and correspondence with the appellant on a number of occasions. It wasn't the case before the First Tier Tribunal. And contrary to what is being suggested today, that opportunity was obviously available to Regency to so prove to HMRC in those compliance visits and various correspondence, and before the FTC, where a detailed consideration was taken of the contracts and of the contracts, as well as the documents in question, the records that were available, that were provided.
You say Ms. Munir does not concede the availability of bad debt subject to compliance with the regulations, because the way that Mr. Ripley reads that sub-paragraph is to say, well, if she's wrong about the legal meaning of consideration, then the conditions exist subject to compliance with the regulations.
My lord, that's correct. She has not made any such concession. And if I can, to make that point good, take you to the supplementary bundle, the first witness statement,
Yeah.
which is at tab 3, paragraph 34, paragraph 7 on page 34, she explains the purpose of the compliance visits that she undertook, which was to allow the business to demonstrate that what happened in practice differed.
So sorry, which paragraph?
We're at paragraph 7, my lord.
Yes.
And so she explains what the purpose of the compliance visit was, for her to be satisfied as to the basis of the bad debt relief claim, and that, in fact, the what happened in practice differed from the stated terms of the contract. And then she goes on at page 35, paragraphs 15 onwards, to deal with the records that were available to her, and the reasons why she comes to the conclusion, which is stated up front, that Regency, she did not believe that Regency had kept the necessary records as required by Regulation 168. Moreover, at paragraph 16, she did not see any evidence of Regency's fees being written off as bad debts in a refunds for bad debt account, which would have allowed me to cross-reference to the relevant invoice.
What she says in a refunds for bad debt account.
Yes, but she then goes on at paragraph 18 to explain what the process she undertook in the compliance, based on what sort of interrogation she undertook. And in paragraph 19, she says, despite the assistance of those present, I was unable to establish an audit trail for the collections selected. And so what she then says in her second witness statement.
And the FTT accepted her evidence.
Yes, my lord, and also
So
had
when we're
benefit.
trying to puzzle out what the FTT meant by the various bits of the decision that Mr. Ripley showed us, we have to factor in the FTT's acceptance of Miss Munir's statement that despite the assistance of those present, I was unable to establish an audit trail.
Yes, my lord, indeed. And the FTT itself tried to undertake a similar process, one could argue, and was itself unable to establish the necessary audit trail in my submission. That is the nature of an appeal before the First Tier Tribunal, where there is witness evidence available to the court, both in writing and orally, and the FTT is able to take that into account.
So even if it was not explicitly analysed before the FTT in quite the way it's been analysed now, you say it was understood, and or certainly should have been understood, that was the opportunity to say,
Here is the proof.
even if I'm wrong about 1683, here is the proof that I did in fact pay.
Indeed.
And then if, sorry, I did in fact pay, here is the proof that I did not receive the relevant payment. And if that had been proved, there might or might not have been an issue of law as to whether the revenue should say, oh, well, in that case, we won't insist on 1683. Yes, thank you.
And in that regard, my lord, it is important to note that there is, in fact, provision within the regulations for HMRC to exercise its discretion in the trader's favour in the absence of the records as stipulated in or required in 1683 or even in 1682. I'm going to have to check that we do have the relevant provisions available in the bundle of authorities. I know we do have at least one of them, and that is Regulation 1661, which is page 20 of the authorities bundle. And that begins, save as the commissioners may otherwise allow or direct the claimant shall make a claim to the commissioners by including the correct amount of the refund. So that is a general provision in my submission which allows the revenue a significant, or power to exercise a significant discretion in the trader's favour, in the taxpayer's favour, in order to consider whatever evidence or proof is necessary in order to validate a bad debt relief claim. And a case in point might be, for example, if records are destroyed, or perhaps more pertinent to the bad debt relief sort of scenario is the well-known BT and GMAC litigation, which relates to the old regime of bad debt relief, which came to an end in 1995, and was replaced by this regime. That old regime had a number of conditions, including an insolvency requirement and a property condition, which was subsequently found to be disproportionate. HMRC had a lengthy transitional period, 7 years, in order to allow for claims to be made in relation to bad debt relief, which was denied incorrectly, HMRC now accepts under that old regime, where the original documentation was no longer in existence, given the passage of time. HMRC has been prepared and has, in fact, allowed evidence in the form of annual accounts, contracts, witness statements, in order to allow a bad debt relief in the absence of specific records.
Are you referring to that? I mean, that's an illustration, you say, of a discretion being exercised. But are you saying that illustrates that HMRC has a discretion irrespective of some particular provision like 1661? Or was that discretion itself based on 1661 or some predecessor provision?
Irrespective of 1661.
Yes, I see. So that's your point.
Yes. But so I also refer to 1661, and then the second.
HMRC doesn't have a general discretion not to require people to pay tax.
No, my lord. Apologies if I didn't make that clear. But to look at alternative evidence in support of a claim for bad debt relief in the absence of the required records.
So you're saying it has an inherent discretion to allow proof of liability to tax or non-liability to tax.
The reduction in the bad debt relief.
Yes, it would, in this particular case, a reduction in bad debt relief, to be made in a way other than that provided for in the regulations. And you're saying that's so apart from 1661?
Yes,
Yes,
my
I
lord.
see.
And then we have 167, which again says, this is on page 22, save as the commissioners may otherwise allow in respect of, and it sets out what's required to be shown in respect of each relevant supply. So again, it's that room for discretion on the part of HMRC. And then specifically 1682, which is part of the regulation 168, which is an issue here, save as the commissioners may otherwise allow.
Those words don't appear in front of 1683 itself.
No, my lord, but 1683 is understood to relate generally to 1683 and what is required there. So if the commissioners have a discretion to allow otherwise in respect of the records required in 1682, it would follow that that discretion would also carry over to 1683 in my submission. And that is in addition to the inherent discretion to look at other evidence, including witness evidence, looking at the annual
Where does
accounts.
that inherent discretion come from? Is that a discretion as a matter of general domestic public law, or is it a discretion which is required in order to satisfy EU law?
I would say both, my lord.
Both.
Certainly as a matter of good administrative practice, one would expect HMRC to look at whatever evidence is available, but also when we looked at the case law on SCT, the Sabinian case, with the Advocate General making clear that HMRC or tax authority should not deny taxpayers the opportunity to claim bad debt relief. So in my submission, we have to look at first principles when it comes to VAT law. And so the principle of neutrality is a fundamental principle, and that is referred to over and over again in the EU case law. If HMRC were to deny a claim for bad debt relief simply on the basis of absence of records per se, if the claim could be substantiated or validated otherwise, so if there was no assurance visit, there was no request from HMRC to a taxpayer, can you please assist, can you show me how you're entitled to this claim, then one could argue that if the taxpayer is in fact able to provide that proof and it's ignored, then that would offend the principle of neutrality. But that's not
in terms of procedure, you've got a compliance visit by Miss Munir and no doubt
Two,
other
yeah.
HMRC officers. She says, well, I've tried to establish the audit trail and I can't. So I'm going to disallow bad
Reason
debt
assessment.
because you haven't complied with the requirements of Regulation 168. So the taxpayer then says, but I can prove the audit trail. And Miss Munir says, no, you can't. I've tried to work it out. It doesn't work. And then what? The taxpayer goes to the FTT saying, well, she's wrong about that. I can prove that I've satisfied all the requirements of substantive requirements of Section 36 and Regulation 1682. And then the FTT would have to
Make a ruling.
decide as a matter of fact whether that is true or not.
Indeed, and in my submission, that is what took place here. And the appellant failed before HMRC and before the FTT to make good its case that it was entitled to a valid bad debt relief.
Well, was that one of the arguments that was run in the FTT, that despite non-compliance, we can prove it? That was one of the arguments run, was it?
I didn't appear in the FTT,
No, I followed.
but that is in essence what was put forward on behalf of the appellant.
Well, I suppose it could be put two ways, couldn't it? You could say, and you are saying on instructions, that it was put that way and failed. Perhaps you may or may not be able to see that from the way the FTT expressed itself. But you could also say that was the opportunity to do it, and if it wasn't put precisely that way, that's their problem, not ours.
And I don't understand that the appellant would disagree with the contention that it did in fact attempt to persuade the First Tier Tribunal that it was entitled.
Well, Mr. Ripley will
Yes,
you
indeed.
can tell us now. It's probably more
But
orderly to tell us when we come back to it in reply.
So that's the first point, the 2 points, which is that there is no concession on the part of HMRC, and secondly, that there is in fact a discretion, which it didn't, in this case, there was no basis to exercise that discretion in the appellant's favour, not at the compliance stage in the assurance visits, nor before the FTT, on the basis of the evidence before the FTT. It's important to remember what is said in the Slovenia case, which is that the burden is on the taxpayer to establish its entitlement to a bad debt relief claim. So I have 3 submissions in relation to this ground of appeal. The first is that the Regulation 1683 formalities, focusing on those, are in pursuit of legitimate and recognised objectives.
Sorry, say that again, Ms. Lemon, I didn't quite catch it.
The Regulation 1683 formalities, or requirement for the single account, that is in pursuit of legitimate and recognised objectives. Secondly, that formality or requirement does not go beyond the strict limitations which have been set out in the case law. And in particular, can be construed in a manner consistent with the principles of neutrality and proportionality, which are key elements identified in the case law. Finally, the 1683 formalities can be distinguished from the case law, which at the time of the grounds of appeal was limited to SCT and the case of E, but which by the time we've come to the authorities bundle, expanded to quite a number of authorities, which I will touch on very briefly for completeness, but those formalities can be distinguished from those which require insolvency proceedings to have been completed, which is the Demora case, for example, which could take some 10 years and really come nowhere close to those sorts of requirements, which are in essence a substantive bar to a claim for bad debt relief.
So, are you going to be separately dealing with the argument about the meaning of the phrase "any records created in pursuance of this regulation"?
I can deal with that at the end, my lord. Dealing first with what is required by Regulation 1683, it is common ground that it is simply an account, ledger, or spreadsheet, which in essence summarizes the information required by the records to be kept in Regulation 1682. That is to be kept in an account which is called, nominally, the refunds for bad debts account. Of course, if a trader decides to call it something else, but it is effectively an audit trail or that spreadsheet, HMRC is not going to quibble with that. But the purpose of that requirement is to allow for an audit trail to be established. And that audit trail is one which HMRC officers, such as Ms. Munir, would then be able to check easily in order to validate or verify.
Would it be fairer to say purpose is to allow an audit trail to be readily established? Depends, I suppose, what you mean by an audit trail. But if 1682 has been complied with, there is an audit trail in the sense that, laboriously,
yes,
you could conduct an audit.
Indeed.
That's why I suggest readily
established. Yeah, yes, my lord. And in fact, before the Upper Tribunal, Regency accepted that that was the purpose of Regulation 1683. And to make that point good, if I take you to the Upper Tribunal's decision.
Yeah, well, it comes first of all with the FTT at paragraph 117, where the FTT says the purpose of having a single refunds the bad debt account is to establish an audit trail that HMRC investigators can easily check. And that is then repeated in the Upper Tribunal's decision, and as you rightly say, Mr. Ripley accepted that. That's at paragraph 88.
Indeed, my lord. And the UT went on to find that that is Parliament's intention in requiring those records to be kept in a single account.
It didn't mean Parliaments, did it? It didn't mean Parliaments.
No. It is also, I believe, common ground that Regency has not kept that ledger or single account spreadsheet. And there is a matter of dispute as to whether, in fact, Regency has all of the records required, for example, to allow HMRC to exercise its discretion. Mr. Ripley says to you today that, in fact, the First Tier Tribunal operated on an assumption in paragraph 177 of its decision, which is at page 98. Where the comment is made that First Tier Tribunal judge said he had no reason to doubt that it keeps the records as listed in Regulation 1682. However, that must be considered alongside what comes later at paragraphs 118 and 119, where he says, referring to the evidence of Mr. Farrell at 119, that Mr. Farrell gives information about particular clients in relation to whom the appellant has claimed bad debt relief. And he says the claims made to BDR are not the amount shown on his analyses. they may be higher or lower. And HMRC has already pointed out these discrepancies. And he concludes, in the absence of a refund for bad debt account, as required by the Regulation 168, it is impossible to say whether the necessary conditions for bad debt relief have been met. My lords, before the tribunal, Mr. Farrell gave evidence. His witness statement, which you have before you in the supplementary bundle, goes through in quite a lot of detail how the claims were made, or attempts to produce a sort of audit trail. And by way of example, at page 26 of that supplementary bundle, it explains, in respect of one of the Regency's clients, Ashley Engineering, it says that the amount, paragraph 90 of the statement.
Sorry, we're at 26.
26, if you look, it's a bit obscure, so if you look at top
Oh,
of the page,
top, I'm sorry, I was looking at the bottom numbers.
yeah, it's,
Right, top numbers, yes.
page 26. So he goes through, as he's been doing for a number of Regency's clients on previous pages, but he explains that for that client, the amount claimable under a claim for bad debt relief would be $3,000, having gone through the calculations, and that aligns with the row VAT 3017.25. But he then explains, however, in respect of the claim for bad debt relief, we actually claimed 3,119.73, which is higher than what appears above. And he gives an explanation for it, but it is indicative of the fact that what was claimed was not correct. And then also, across the page, RBL, which is dealt with...
So you say across the following page, yeah.
Following page. RBL, another client, a claim of 4,500 was made, which appears to be 3,598.97 less than they were entitled to. So again, another discrepancy. And similarly, another discrepancy in MKL Group. We go down the page, dealt with paragraph 98 to 105, where VAT of 3531 in paragraph 103 was reclaimed, whereas this should have been limited to 2,200.
So sorry, I've just this is on page 28, is it?
This is on page 28.
And which paragraph?
Paragraph 103.
Yes, thank you.
And again, Raymond Reed, paragraph 111. We have the amount being reclaimed being higher than should have been the case. Mr. Farrell goes on to deal with the fact that in respect of specific clients, there's been an overclaimed bad debt relief. At paragraphs 150 and 151 of his witness statement on page 32, by making the point that if we were to look at Regency's VAT return for the quarter in question, we are a net payer of VAT, and as such we are simply reclaiming part of the VAT and of those charges. As such, we do not see how this breaches the rules for bad debt relief. My Lord, that in my submission demonstrates precisely the reason why the requirement in 1683 exists. It is more than a mere formality or requirement to duplicate records which might exist as set out in 1682, Regulation 1682. It is in order to ensure that there is correct collection of VAT. It is in order to ensure or to eliminate the risk of loss of tax revenue. And it may be, as well, in order to prevent evasion, which is not a salient point in this appeal, but certainly when it comes to the issue of correct collection of VAT and eliminating the risk of loss of tax revenue, there is a valid concern on the part of HMRC in having a clear audit trail which readily establishes or validates a claim for bad debt relief, not only the quantum of that claim, but also that it relates to the correct, it's in the correct time frame, because there are specific time requirements in the regulations, that it hasn't been claimed before. HMRC needs to know this or have this information, and that is the purpose of the single account in 1683. And those objectives are recognised and legitimate objectives which are permitted by the Principal Vat Directive, as set out in Article 273, which you've been taken to already. And I would also add that it's within the margin of discretion which member states have available to them. I will go through the case law in some detail, but not, there is a lot of case law. In my submission, one needs to bear in mind the objective of fiscal harmonisation, but also the established principles of neutrality, fiscal neutrality, and proportionality. A convenient starting point when looking at the case law, which I'll turn to next, is the Kraft Foods case, which where you ended with Mr. Ripley. And I'd preface my analysis of the authorities in this way, which is that the cases of TAVE and SCT and the additional cases which my learned friend has provided to the court do not, in fact, attempt to change what has been said in the earlier cases. There is no evidence that the court in Tratave has disavowed any of the points made by the court in Kraft Foods, for example. Rather, all of that case law, that body of case law, can be considered to be the CJAU boilerplating, or providing the same explanation to various member states who come to the court for guidance as to whether various conditions or requirements or attempts to derogate from the bad debt relief provisions is permissible. And so we have a number of different conditions, and the court in each instance looks at the conditions, sets out the principles, which do not vary, and then decides whether or not the relevant conditions are justified or permissible in each instance. And Kraft Foods and Tratave are the two cases where the court held that it was those conditions which were imposed were justified, whereas in the other cases, and particularly the case of Demora, which required that you had insolvency proceedings come to an end, which would take in excess of 10 years, that went too far, is not justified. And the court in each of those decisions looks at the principles of neutrality and proportionality, often using exactly the same phrases, but with a slightly different, it's obviously set out differently. So, Kraft Foods, that appears at tab 27 of the authorities bundle. And paragraph 19 on page 307 summarises what the condition in question was, which is that the taxable person must be in possession of an acknowledgement of receipt of a correct
Sorry, where are you? Which paragraph?
Paragraph 19, my lord.
19.
Yes, my lord. On page 307.
Yeah.
So there must be a correcting invoice by the purchaser of the goods or services, which is a condition. And so it looks at, and it says whether it may constitute a condition for the purposes of Article 91, and whether the principles of VAT neutrality and proportionality include such a requirement. So that's what the court is asking itself on each occasion. At paragraph 23, the court makes clear that there is a margin of discretion, because there is nothing in Article 90 or Article 273 of the Principal Vat Directive specifying the conditions, obligations which member states may impose. But it goes on to say, at paragraph 26 and 27, to explain that the principle of neutrality, to look at the principle of neutrality. In other words, it says at paragraph 27, it's one of the fundamental principles of the VAT Directive, according to which the basis of assessment is the consideration actually received, and the corollary of which is that the tax authorities may not in any circumstances charge an amount of VAT exceeding the tax paid by the taxable person, which really should be the final consumer. And then over the page at paragraphs 28 to 29, it makes clear that measures to prevent tax evasion or avoidance may not be used in a way that they should have the effect of undermining VAT neutrality. And then at paragraph 29, which you've looked at with Mr. Ripley, makes the point that if the reimbursement of the VAT becomes impossible or excessively difficult as a result of the conditions, those principles may require that member states provide for the instruments and detailed procedural rules necessary to enable the taxable person to recover the unduly invoiced tax. So in other words, it shouldn't prevent a valid bad debt relief claim. This is not an unfettered discretion. And if your lordships would also consider paragraph 38, sorry, at paragraph 33, before I come to paragraph 38, it makes the point that we are looking at the legitimate objectives. The requirement at issue in these proceedings may in principle contribute not only to ensuring the correct collection of VAT and preventing evasion, but also to eliminating the loss of tax revenue, which are legitimate objectives set out in Articles 90 and 273. One point at paragraph 38, my lords, which is important to highlight, is the court recognised that VAT neutrality is affected when it is impossible or excessively difficult for the supplier of goods or services to obtain such acknowledgement of receipt within a reasonable period of time. So it's all part and parcel of the principle of neutrality. One needs to consider, is it impossible or excessively difficult for a bad debt relief claim to be made? And that point is then made at paragraph 40, where it said, if it is impossible or excessively difficult for the supplier of goods or services to recover within a reasonable period, because of the condition at issue in the main proceedings, the principles of VAT neutrality and proportionality require the member state concerned to permit the taxable person to establish by other means. So that's simply to make the point that one needs to look at what are the objectives, and also the principles of neutrality and proportionality cannot be undermined by any condition that is imposed. The next case, very...
We'd see it's the same Advocate General who's responsible for the observations my Lord cited to you, so if you can give an opinion in this particular case.
Yes.
Yep.
Right. Advocate General Cookott features quite a bit in many of these cases. The next case, which is Almos, which is at tab 26, I can look at very quickly. Again, the principles are reiterated almost in the same way. In particular, and if I may, my lords, I'll give you the references, but not read them out.
That sounds, well, frankly, if it's simply the European Court doing what it normally does, I don't think we even need the references, do we?
My lord, I'm in your hands, but perhaps I'll go through a few,
All right.
and then when you've had enough,
What?
you can stop me, or if I
Okay, give us the references then.
Almost, again, we've got at paragraph 37, which is the same as at Craft paragraph 23. And again, paragraph 39, which says that the formalities to be complied with must be limited to those which make it possible to provide proof. So it's saying the same thing in a different way. Just of note, whilst we're on that authority, at paragraphs 23 to 25 of this decision.
Sorry, I didn't turn it up because I thought you weren't going to require us to. But which tab is it?
So it's tab 26.
Yep.
And
Okay.
it's page 299. Simply to make the point there that the court deals with the margin of discretion, and what is said in paragraphs 23 to 25 could be taken to suggest that there is an unfettered unfettered margin of discretion. The European Court in subsequent cases has made very clear that there is no unfettered right to impose conditions or to impose exceptions to the bad debt relief, to derogate from the bad debt relief requirements. And that demora is the case that is perhaps that deals with that most clearly. That one I've already mentioned is the Italian requirement that insolvency proceedings had to have been concluded and unsuccessful, and that would have taken some more than 10 years. And the European Court held there that there was no unfettered right to derogate from bad debt relief or for member states to exclude taxpayers the right to make a bad debt relief altogether.
Are you taking us to this, or are you just telling us about it?
I was telling you about it first, my lord. However, the passages which you may want to consider are paragraphs 17 to 18.
Which tab?
This is demora, is it?
This is the Mora, tab 21. And where it says, is this court's settled case law that exceptions must be interpreted strictly, and there is the EU legislature did not confer on them the power to exclude bad debt relief altogether. And paragraph 23 refers to the principle of neutrality, and then paragraph 25 to the principle of proportionality. And then at paragraph 27, it also makes the point in the middle when it says, it is clear, sentence beginning, however, it is clear that the same objective could also be pursued by granting the reduction when the taxable person demonstrates a reasonable probability that debt will not be honoured. And thereafter, my lords, we are faced with a number of authorities which go on to say exactly the same thing. You can take into the passages in Tratave. I don't propose to take you to the same passages again. APAC, again, it's a check requirement in relation to insolvency. Again, it was held to be unjustified and to offend the proportionality principle, paragraphs 23 to 24, my lords, if you'd like to look at that at any point. And of course, SCT, which you've also been taken to. ESP, similarly, is the same principles being set out at paragraphs 20 to 25. Nothing in those authorities, not even the last two, which were provided by my learned friend FGSZ, which is at tab 10. Again, that takes matters no further in my submission. Paragraphs 18 to 20 again refers to.
Well, if these are cases that Mr. Ripley put in and which he sensibly has not thought it necessary to refer us to, I don't think you need to deal with them.
I'm grateful. So the simple point in my submission is that, as explained by the CJAU intra tabe, the formalities must be limited to those which are strictly necessary and make it possible to provide proof that part or all of the consideration will not be recovered, so that there is a valid bad debt relief claim, I paraphrase. However, it cannot offend the principles of and objectives of the Principal Vat Directive or undermine the principle of VAT neutrality. And, my lord, I would say that, as I said at the beginning, that the requirements in Regulation 1683 come nowhere near to those requirements which are dealt with in the various authorities which are before you. Those were found to be disproportionate and impermissible. They require things such as completion of insolvency.
But are you accepting a statement that the Slovenian case shows that, perhaps not always, but in some cases, a strict rule, a strict formality rule, may contravene the principle of proportionality if there is not a discretion for it to be disapplied if the taxpayer shows that, notwithstanding non-compliance with the formality, it has in fact incurred a bad debt. That seems to be what we're being invited, that is what we're being invited to take out of the Slovenian case. You have explained how, if that is the rule, it doesn't create you a problem for you in this case. I just want to know whether you accept that that is indeed, as it were, a general proposition. Seems to be.
If I may just check. I just wanted to check, my lord, but yes, we would accept that. Obviously, the trader, which the European Court has likened to an unpaid tax collector, shouldn't be required to bear a VAT debt, which for VAT which hasn't been received. So if it can prove that there is, in fact, a valid entitlement to bad debt relief because there is an outstanding debt which is not recoverable, then it would be wrong if there was a condition which didn't allow, or if the
you had no discretion.
Indeed.
So does that get you to the position that there is nothing wrong with Regulation 1683, provided that it is tempered by the various discretions given to HMRC elsewhere in the regulations and under the general law? That's where you end up?
We do end up there, but before that, there is the point which must be made, which is what is required in 1683 doesn't go beyond the margin of discretion.
Yeah.
It does. It is in pursuit of a legitimate and recognised objective, and also then, even if there isn't a single account as required by 1683, the provision or the fact that HMRC is able to exercise its discretion to recognise a valid claim evidenced otherwise, then ensures that the regulations do not fall foul of the VAT principles. My Lord, I think those are the extent of my submissions.
Well, you've got to deal with the records created as opposed to records kept.
My Lord, yes. That point, which was raised for the first time in the Upper Tribunal, in my submission, is...
Well, does it matter? It's a question of construction of regulation.
Yes, it is of no merit because it doesn't take away from the fact that all that Regulation 1683 is asking for, in essence, is an audit trail. So whether the trader creates the records in order to produce the audit trail and then transposes that into 1683, or whether the trader is looking at a bunch of records which may be in boxes or files or computerized, so which were not created for the purpose of 1683, but in order to then create an audit trail for the purpose of 1683. In any event, my submission is that we need to get to the point where there are records in a single account or ledger spreadsheet which HMRC can look at in order to readily verify a claim.
I mean, are you saying that the sense in this context of created in pursuance of this regulation is effectively more like relied on in compliance, relied on in order to establish compliance?
Yes, my lord. That's perhaps a more elegant way of putting it.
Well, I'm not sure. I'm just trying to get the sense of it.
It's the regulations which, or sorry, the records which are behind the audit trail. So whether they are specifically created for it, one would not expect, for example, out of thin air to produce an audit trail. That would have to be based on primary records. So, and if you're looking at 168, the trader would be expected to look at all of the records available to it in order to create an audit trail which is contained in a spreadsheet or ledger.
Well, that's the way that VAT works effectively. The trader puts in his claim in his VAT return, and if HMRC want to investigate it, they do a compliance visit, and at that point they're presented with the records and they work out whether the claim is or isn't justified. And if they have to spend days trawling through bits of paper in boxes, that rather defeats the purpose of checking to see that the claim is a valid claim. That's essentially it, isn't it? I mean, you might call that administrative convenience, you might call it effective policing of the VAT regime.
Yes, my lord, and also it's important to have regard to the fact that in order to make a claim for bad debt relief, a trader doesn't have to, on the VAT return, put it in any particular form other than to enter a number in the correct box. So in order to check that that figure claimed is correct, there needs to be that ledger or spreadsheet which HMRC can then check the claim against, which will in turn be based on the records which the trader must have, and which 1682 makes clear are required.
Yes. Anything else?
No, my lord, unless I can assist you further.
No. Thank you very much. Yes, Mr. Ripley.
If I may, I'd just like to start with Ms. Munir's first witness statement. A few points to make in relation to this. In particular,
Let's just
let's open it.
let's just go down it.
So, I think it's tab 3, it's page
Yeah.
33 onwards. Paragraph 19, I think, was one of the particular ones which was discussed in exchange. And it says there, despite the assistance of those present, I was unable to establish an audit trail for the collection selected. Now, the first point to make is that this witness statement is only describing what happened during the compliance visits. It is not describing the records or before the First Tier Tribunal. In the First Tier Tribunal, there was greatly more evidence provided than had been before the revenue previously, as the taxpayer was entitled to do. The learned friend suggested, nevertheless, that the revenue had difficulty establishing the audit trail, and the FTT did also. But as I said when we went through the decision, the FTT proceeded on the basis that we could produce all of this information, and then penalised us because it wasn't in a single ledger.
So this really comes back to your point about 117.
It does. There is no finding that we had no evidence to support our claim. And I do not leave aside the point which my learned friend took you through in detail about discrepancies. And I'll come back to that in just a moment.
Okay.
Before I do, there was a point which my learned friend made about the chronology here. And there was a suggestion, I think accepting what my Lord Lewison put to my learned friend, that the chronology here, there was a compliance visit. The revenue said to Regency, presumably, there was no audit trail, and that the revenue refused bad debt relief on that basis. Now, my understanding of the background is that is not what happened. I don't understand there to be any facts found to that extent. And what we do have is the revenue's decision. I skated over it before, but I think I ought to show it to you. It's in the core bundle at tab 11. This is the revenue's decision letter. This is what is being appealed. It's at page 100. So it starts with saying, may I take this opportunity to reaffirm the ruling given in my letter 28th April 2011. We don't have that letter in the bundle, and I don't believe I've seen it. Then the first heading is bad debt relief. From our discussions and the information provided, it has been established that the standard rated factor charges made by Regency to their clients have been netted off against the purchase price of the client's debts. So that's the respondent's notice point. I have not seen here any reference, and perhaps somebody could correct me, but I don't think there is any reference here to the record keeping.
I mean, how far does this get you? You were appealing against that decision, but as I understand it, in the FTT, all points can be taken by both sides. And perhaps this is the point you're coming to. Ms. Lambert says that whether the audit trail could be established from the records produced at the FTT was considered.
Yes.
And gone into in some detail.
Yes.
You have your point about what the FTT found.
Yes.
And you'll come back to what she says about that in a minute. Does it really matter what the basis of the decision was?
I'm not taking the point that the revenue was somehow limited to the reasons given in their decision.
Right. So, but then, what point are you making for not making that point?
I'm sorry. It does just come back to the discretion point. So, It isn't the case that the revenue said we're going to refuse on this basis, now prove it. And we did go to the First Tier Tribunal. I mean, perhaps that's as far as it goes. But in those compliance visits, we weren't at that stage understanding that we were going to be disallowed bad debt relief on the basis of our record keeping. And perhaps that's as far as it goes. As you say, the learned friend then accepted that Regency did attempt to show that it had all the records and that there was an audit trail in the First Tier Tribunal. So that much is common ground. And they still say that Section 1683 is to establish an audit trail. And you have my point. I accept that. The regulation 1683 is there to establish an audit trail, but to the extent one doesn't exist. That's what establish means. Now, 119 of the First Tier's decision, and we can turn it up if you wish, but it was the reference to the discrepancies. And my learned friend took you through the various discrepancies in Mr. Farrell's witness statement. Now, one needs to be clear here about the function of the FTT. They have the ability to raise or lower the amount of bad debt relief. And so a taxpayer is quite entitled to say, I claimed on this amount, the revenue have disallowed all of it, but actually I should have had a slightly different amount. And if need be, I can give you the references to the powers of the tribunal to lower or raise an assessment. But what doesn't get to happen, and certainly not in an Article 90 context, is for the revenue to say that there are some discrepancies that you've accepted, or for the tribunal to do this, and say that means you get nothing, even if you can show you did have an entitlement to bad debt relief by reference to your records. The only way they get to you can have nothing is if they can show a breach of Regulation 168 and they're entitled to
I don't think that's the point for which these discrepancies are being relied on. I think they're being relied on to say, well, look, the accounting records are so difficult to understand because of this pari passu method and all the other things that Mr. Farrell spoke about, that you can see that even in this case, the requirement of a single account under Regulation 1683 does serve a useful purpose because it serves to ensure that the correct amount of tax is collected, whether that is higher or lower than the amount that Regency has claimed. I think that's what that's why it's being relied on.
I understand. It brings me to my next point, which is that single account doesn't do that. It doesn't ensure the correct collection. Because if Regency had kept that single account, the numbers
would
could
have
still
shown
be
all
wrong.
the same errors.
The same discrepancies. The way in which this was resolved in the witness statement of Mr. Farrell was by reference to the underlying records. And in my submission, that shows the fallacy of the submission that a single account is what creates or what ensures the correct collection.
Well, it's not ensures. It makes an audit trail a lot easier. Or it makes the audit trail, the process of establishing the audit trail, if you like to say, much easier. May or may not. If the audit trail shows mistakes or overpayments or underpayments, that's fine. That's what an audit trail is supposed to do. That's the substance.
Indeed. But in order for it to be a permissible recognised objective under EU law, it needs to ensure the correct collection of VAT.
No, it doesn't need to ensure it. It's to facilitate it, surely. I can't remember whether the phrase ensure is used in the case law, but spreading it out, if you have a procedural requirement, one of this kind, the ultimate aim, of course, is to ensure the correction of correct amounts. But the creation of an audit trail is to make it easier to find out whether that has in fact happened.
I accept that it is to make the auditing more straightforward, although you have my
But are you saying that that's not even a legitimate aim?
I do say that as my starting point, because it's simply making it easier is just too loose a condition. In effect, the revenue could add all kinds, or the UK could add all kinds of conditions which are said to make it easier, providing it in a particular form by a particular time in a particular way. Those things might be more convenient for the revenue. But I do say that kind of convenience falls short of what the Court of Justice means by ensuring the correct collection of tax, which is the touchstone they use in the cases. But even if it's permissible, so even if I'm wrong about that, I do say that it goes beyond what's strictly necessary as well. And perhaps just on a related point, I don't want the court to think that our case is that the revenue is required to turn up at businesses and trawl through boxes. They are quite entitled to say, show me your records under Reg 1682 and prove to me your entitlement. And when we get to the First Tier Tribunal, I also accept that the burden is on the taxpayer. The only question here is whether or not Regency was really given the opportunity to establish that audit trail. Can I just, at this stage, just briefly look at 1682 so we see what records are there and what it really helps with. It's behind tab 7 in the authorities bundle, page 22. Now, I infer that the difficulty here, although my learned friend didn't identify the particular thing in Reg 1682 that's said to be missing, but I infer the particular difficulty that for the revenue here is 1682A4. So that's in respect of each relevant supply, so that's the supply by Regency, any payment received therefore. And the difficulty here, of course, is because of the nature of Regency's business and what it means to receive payment here. That includes collections from the customer. And it's the difficulty of allocating those collections to the supplies which Regency has made.
Yeah, this is a related point under Regulation 1722, isn't there, as well? That the date on which the debt's written off is the date on which the entry is made in relation to that supply and the refunds of bad debt account in accordance with Regulation 168. So that triggers time limits for, may or may not satisfy time limits for making a bad debt relief claim.
May I just read, is this 1722?
Yeah.
For my part, my lord, I hadn't read 1722 as stating, as being about the time when it's made, but rather it's saying, so perhaps if we start with 1721, this regulation shall apply for the purpose of ascertaining whether and to what extent the consideration is taken to be written off.
Is to be taken.
To be taken to have been written off as a bad debt. And so what 1722 is doing is saying, if you write it off in your bad debt relief account, you are taken to have written it off for the purposes of section 36(1)(b). So Reg 168, if I may. Subparagraph 2.4, so it's that bit, the any payment received therefore. As I say, Regency had identified a number that it said it had been paid so that it could work out the outstanding amount. What the revenue are missing, and what the tribunal may well be complaining about, is the calculation of that number. But that calculation is not a requirement of Reg 168(2). And so if the complaint is not that you didn't meet the requirements to keep all your statutory records, but rather the requirement is, but rather we would have liked to have seen other things, then you're still back in a situation where Regency bears the burden, but it's decided on the balance of probabilities, and there's no strikeout for not having something which was not a statutory record. Unless I can help you further on the sort of the regulations and the fact side of it, I was just going to look now briefly at Kraft Foods Polska, which is a case Malone and Friend took you to, and Malone and Friend said there's been no change since Kraft Foods Polska. Boilerplating of decisions means it's essentially the same. But I think it is worth just looking at the decision again. Give me a slow to find it. Tab 27 in the authorities bundle. In fact, it's page 308 of the critical paragraphs that Malone and Friend took you to.
Sorry, which page did you say?
308.
308.
The first point to note, I'm sure Malone didn't mean to skip it, but paragraph 28 does refer to within the limits strictly necessary. And then rereading that paragraph, I considered an exchange which we had earlier. The paragraph starting consequently, it suggested that this might imply that what's meant by strictly necessary is restricted to that becoming impossible or excessively difficult. But that's not what the court says. The court puts it the other way around. It says, if the reimbursement of that becomes impossible or excessively difficult, those principles may require that member states provide for the instruments and detailed procedures necessary to enable a taxable person to recover unduly invoiced tax. What it doesn't say is that if something is not impossible or not excessively difficult, then that is within the limits of the strictly necessary limitation. So I don't read Kraft Foods Polska as being inconsistent with the later decisions. And in any event, none of the later decisions which we looked at use that same touchstone of the principle of effectiveness. Unless I can help you further, but that is my reply.
No, thank you. Right, well, we'll sit again at 2, at which point we'll consider what happens next. But you should certainly be prepared to deal with the respondent's notice point. Thank you.